exhausted all avenues of appeal. It is the hope of the prosecution that this will bring closure to the SRC hearing or the SRC case. This decision by the federal court is also a vindication that the charges against Dato Sri Najib are legally mounted and not politically motivated by the prosecution. And there's always a question, how do we feel the prosecution? I must tell you, there is no joy in a successful prosecution except that the Attorney General's Chambers has been able to ensure that the rule of law has prevailed in this case. The SRC prosecution's biggest message is to politicians or other likely offenders is that this prosecution has shown that no man in this land is above the law. And I want to stress, this successful prosecution must send a chilling message to all would-be offenders that the law will catch up with you and punish the guilty. So that's all I want to say on what the prosecution wishes to say. Is there any question you wish to ask?
Yes, since there's a dissenting judgment, is there room for another review?
Well, I must say there has been legally a review is from a decision of the federal court. There was a decision of the federal court, and from that decision, this review. If you want to review upon a review, then there's no stopping a review upon a review and a review upon a review, and you can send your grandchildren here to take notes again. You follow what I'm saying? So legally, there is a possibility, but it is very unlikely.
What about your comments on the judgment by the single judge?
No. As lawyers, we accept both the judgments. It is their view. I can't give my view. I'm not a judge, but it is their view, and we accept the decision. Yeah. Oh, okay. Of course, you all know that the prosecution we started with 12 prosecutors at the High Court. Then it slowly dwindled. Some of them retired. Some of them left service. So we are now left to 5. I think, as you all would have seen, we have a very good team spirit. We work with each other very closely. Although I'm based in Penang, we are always in communication. And when they come to Penang, they come and see us. We discuss cases. And similarly, I come to the AGC and we meet up very often to be abreast with the development in this case. Yes. Anything else?
What about the Najib and the UN?
Okay, that is actually something outside our judicial system. I mean, appeal to UN is not provided in our law. Obviously, it's in the international law. One thing I can say for sure, that whatever the decision is not binding on Malaysia, unless Malaysian government wants to accept it, So it is a process. Yeah. Yeah. Okay. All right. Okay. Thank you. Thank you very much. Thank you. Thank you. Thank you. Thank you. Thank you.
Hello，荧幕前的观众朋友，大家中午好哦！现在呢，已经来到了中午的12:10。那么刚刚呢，发表这个谈话的就是纳吉的这个案件的主控官西旦巴兰的。那么跟大家简单快速的说一下，因为今天呢，主要在布城司法宫呢有2大的案件，就是这个前首相纳吉的 SRC 案，还有这个文型脚车8死案。那么他们的这个关键人物就是纳吉，还有这个文型脚车的这个被告，也就是沈可婷。那么其实刚刚如果有看我们较早前的上一个直播的话呢，就已经可以知道，就是纳吉在去年申请检讨终极裁决呢，这个结果是已经出炉了。那么联邦法院呢是以4-1的多数裁定驳回前首相纳吉他寻求检讨这个 SRC 洗钱案终极判决所提出的这个申请，所以这意味着纳吉败诉，他就是必须得要继续的在这个监狱服刑。好，刚刚我们提到嘛，总共呢是有5司，那么呢有其中的4票呢，分别是裁定驳回的，就是有这个联邦法院的法官王南吉，然后还有就是罗德兹、扎利亚、诺丁哈山以及上诉庭的这个法官阿布巴卡。好，我们等会呢再跟大家跟进哦，因为现在呢纳吉的代表律师沙菲仪呢已经来到了这个大厅，我们把镜头转一转。
Just in case. Some. Okay, are we ready? Yeah? All right. I want to make, I won't promise a short statement. If I say short, I go long, then you may complain. Now, I want to make a sufficient statement about what I think are the 2 judgments that was handed down today. All right? as you can appreciate, there is a 4-1 decision. I must say, with the greatest of respect, that we were extremely disappointed with the reasonings provided in the majority judgment, because it sounded like the judgment of the previous federal court with a little bit addition of some flesh. Nothing much that was added that would have impressed us that we were wrong. Okay. For instance, cases that we have obviously shown to be completely non-applicable was cited again, just as the previous federal court cited, like the Halaman Perdana case, which has got no application whatsoever. And conveniently, they did not handle the issue of the circular, about the circular that was applicable to the lower court, which was also given CCs to the High Court and the Supreme Court regarding the discharge of counsel. They did not deal with it. Okay, and in the end, of course, we are further disappointed with the conclusion and the result of the majority judgment. But we are very encouraged, and I must say this, you can see that in spite of losing this case, I am still in the smiling mood because of what was said in the minority judgment, the dissenting judgment, which took double the time of quick reading than the majority judgment. In fact, it was 84 minutes of reading, and the previous, the majority judgment was only 48 minutes of reading. Of course, length or quantity doesn't matter, but it is the quality that is important. Now, I thought highlight to you, this is what was held in the minority judgment that sort of excites me, because it is something which I expected a judge of the caliber of Rahman Sabli, the Chief Judge of Sabah Sarawak, to come up with, going by the historical background that we know about all his judgments, which are quite illuminating and upright. Okay. Now, he said this. He said, out of the 4 grounds, he was only interested to make a decision on just one ground, namely the adjournment, which is the second ground out of the 4. Yeah. So he says on the adjournment, and he started by saying that Rule 137 is critical because it is a rule that not only is to propagate justice, but he calculatedly used the term, it is to stop the perpetuation of injustice, suggesting that what is going on with Datuk Sri Najib was injustice, and he has to stop that perpetuation of injustice. So he said Rule 137 is applicable in such a situation. That's important. And he says Rule 137, even if you go by the law, is applicable when fair trial has not been given to a person. And in this case, he went down the route and held that fair trial was not given. The process was completely not provided to Datuk Sri Najib. Now, this is how he says it. He says that justice is not about finding out whether someone is guilty or innocent, or not guilty. Guilty, not guilty, or innocent. Justice is not only about that, but justice incorporates a bigger concept, namely whether when you come to the decision whether a person is guilty or not, did you apply the process that will enable him to say, yes, I have been given the fairest of trial.
but unfortunately I lose, or fortunately I win. So the process is very important. Now, why you need to stress this is because it applies to you and me. Next time, maybe it's not you. It could be your children, it could be your father, it could be anybody. If he is charged in court, you must be confident that the court will give you a process of fair trial. Because only the process of fair trial, you can be assured that the judges is giving you the chance to prove your innocence, or for the prosecution to prove your guilt. So if you don't get this, then you can say virtually that fair trial was not given to you. Now, I want to jump a little bit. This judge in the minority held that there was no fair trial. The adjournment should have been given, he said, because why should the adjournment be given? He said because the new lawyers took over the case only 3 weeks beforehand. Okay? But he said it is not relevant about Shafi and Co. that was already there 4 months before, because Shafi and Co. was no longer the lawyers, because they were replaced by Ziz and Hisham. So you have to consider the new lawyers. So the new lawyers had only 3 weeks to read over more than 30,000 documents and judgment, which are 800 pages in the High Court, and another 300 plus pages in the Court of Appeal. So you see, it is humanly impossible. So in the context of that, he said adjournment should have been given, and he says it is routinely done in especially serious cases. And you remember we cited the case of one person who got 70 odd adjournment. You know, nobody complains about it. Yeah, because if he needed the 70 adjournment, he should get a 70 adjournment. But this is the first time we ever asked for adjournment. Never before in the history of Datuk Sri Najib. So I want to impress upon you that because he thought fair trial was not given to my client, this judge did not order for a retrial in the federal court. He said because the infringement is so drastic, so big, he ordered an acquittal and discharge. That means if Rahman Sabli was the majority, Datuk Najib today is acquitted and discharged, and there's no more trial on the SRC. It is that serious. And he's the most senior judge there who decided today. So bear in mind, we pleaded either you acquit and discharge, or you order a retrial before a newly constituted federal court judge on the appeal. I mean, the appeal be reheard, because Tunku Maimun and her 4 judges did not hear us. You remember we said they heard the prosecution ex parte, one-sided. They never heard from us at all. And they held that when Hisham stood up and said he cannot submit, it is not because he refused to submit. It is because he's being responsible. He has not been prepared, because he just got it 3 weeks earlier. And therefore, he cannot do injustice to the client by submitting when he's not prepared. You know, like if you are being defended by a lawyer, you will be very, very upset if the lawyer is not prepared, and yet he carried on with your defense, because that's the best way to hang you. You know, sometimes the lawyers themselves can hang the client. It doesn't have to be the prosecution. So the lawyer must be fully prepared in order to defend you. And this is your basic. Right? Okay, now, then he went on about the adjournment. He said, why shouldn't the adjournment be given? Because the adjournment was requested a lot earlier. The prosecution did not object. On 2 occasions on record, he read it. The prosecution leave it to the court, no objection. Not only that, the prosecution sent the Solicitor General. This is the 3rd occasion. The Solicitor General stood up and said, we leave it to the court on the request for adjournment. Which means they were quite confident, the prosecution was quite confident that the request for adjournment was genuine, because they need to prepare. There was no such thing as, was it applied to delay? Because if it was applied to delay, the prosecution will make noise. The prosecution at that time never had any idea that this was a ploy or anything like that. They all thought this is a genuine request for adjournment. And it remains a genuine request. But only here, they began saying that this is a ploy for adjournment, which the judge just now gave them a rap on the knuckle and says this was an afterthought. All right, so the minority judgment say once the application for adjournment is genuine, you have to consider it in a reasonable fashion. You cannot simply say this is a discretion of the court, because the discretion of the court must be exercised judiciously. That means just because it is discretion, you cannot do as you like. You have to consider judiciously, because if you don't grant adjournment, it may cause injustice to this man. So that's why you have to be judicious about every decision, including for adjournment. Now, then we went on to a sub-issue, which is this. He says, he examined this concept of, can a counsel discharge himself? You remember Hisham discharged himself at one stage. On the 18th, he discharged himself. But the court said, no, we are not allowing you to discharge yourself. This dissenting judgment said, there is no such thing as not allowing, because the circular, as well as the two cases we cited, when you engage, assuming you engage me, it's a private contract. The court cannot enforce it. The court cannot say, you must continue engaging me, because that's enforcing a specific performance. If she wants to sack me, that's it. The court have got no say, because it's a private contract. So the court says, this was a private matter between the client and the solicitor. If the counsel says he is discharging himself, the court has got nothing to say about it. In a criminal case. Now, a dangerous precedent was set today by the majority. Now, the bar counsel representative was there, and I'm sure she's very concerned. Now, they say, in every criminal case, for a criminal lawyer to discharge himself, he must seek the permission of the court. Now, you tell me, in a last-minute appointment of lawyers by, say, people who are without lawyers, say, legal aid people, people who are without money, like indigent client. If suddenly they say they met you in court and they say, can you help me? Can you defend me? No lawyers will accept, because the court will force them. You accept, you jalan the case, although I'm not prepared. That is the dangerous precedent which the court majority judgment has set. Whereas previously, if I'm not ready, I ask for an adjournment. The court always, I've never come across one single case where the court never give it, unless it is habitual that you've been asking 5, 6, there's one case 17 times asking for adjournment, so the court can stop you. But in a genuine case, in order to achieve justice, the court always gives you the adjournment. And the discharge of counsel is the counsel's privilege together with his client. So the court decided today, in the minority judgment, that it is wrong not to discharge, not to allow the discharge of the counsel. In fact, the court went in a conclusion by saying, the reason why the Chief Justice or the previous court insisted that Hisham stayed in court was to give it the appearance, is a pretended impression that my client was with a counsel. That's why it doesn't allow the discharge. That's very dangerous, because if you have a counsel that is not prepared, it is as good as not having a counsel. You remember the Chief Justice decided in one case, I did. It's called Yahya Hussein. Yahya Hussein was previously defended in Tawau by a lawyer who never knew anything about criminal law, especially dangerous drugs. And what transpired was, he collected the money upfront and he pretended to defend. And then we realized later on why he wanted to do the case, because the lawyer was dying of cancer. So he needed the money, took the money, but he didn't defend. And he was almost going to be sentenced to death. Then the embassy called us, and then we read the record. See, this is crazy. The IO was not cross-examined. Main witnesses were not called. The wife who was present in court was not called, and so on. So we applied for additional evidence, and Tunku Maimun held that, among other things, she said, an incompetent counsel is as good as no counsel. In fact, she said, an incompetent counsel is worse than not having a counsel, because an incompetent counsel can compromise your case, because you are as though represented and yet not represented effectively. So if we apply that case, you force Hisham to stay there in order to give it an appearance of being defended, and therefore the minority judgment said that is illusory. I mean, to give it an illusion that justice was in fact being provided in the process towards justice. So those are very strong words used by the minority judgment. And finally, he held, therefore, that on the basis of no adjournment, on the basis of discharge not allowed, this is a serious transgression into Article 5, the right to a fair hearing and the right to counsel. And therefore, he said the transgression is so major that he said he orders an acquittal and discharge, not a retrial. Okay, that's the short of what transpired today. If you want to know further, you can ask me. But if you have any other question, you can also ask me. Okay, this minority judgment has given me a lot of encouragement. We have just heard from United Nations that our application in United Nations has started being processed, and there is movement to ask the Attorney General to respond. So we would send further documents, including the minority judgment, to them so that they will examine, because now there is a judicial finding. Okay, we will also send the majority judgment so that the United Nations will see which judgment is a lot more sound. They will see it and then they'll come back to us. That's number one. Number two, on the power of pardon by the Yang di-Pertuan Agong, it's very critical that Yang di-Pertuan Agong has got the opportunity to read the minority judgment, which condemns the way the case was being handled. And I use the word strongly because the minority judgment literally condemns how the previous federal court conducted themselves in not allowing the adjournment and in not allowing the council to discharge themselves. Only on this issue. He didn't even have to go on the other three issues. He already made finding quite clearly that this is a very bad precedent for an unfair trial that was executed on that part. So these two, definitely. But there is a possibility of another action in the court. This one I don't want to disclose yet because we want to organize our thinking in the light of the judgment which we are going to collect in a short while. And we will inform you in due course what we are doing. So it is not the end of the matter. Yes. Apa dia? Oh, no. No. How do you pay 200 million? When the 200 million has been, all the money that was put in the account was spent on charity and political purposes, not for his pocket. It's all spent. So, quite clearly, that money, you cannot recover because you paid it towards welfare, towards political funding, and so on.
So you mentioned there's another possibility in the court. Is another review, another option
that one we cannot disclose yet, whether it's a review or another procedure.
But it will be a court procedure.
It can be a court procedure because the other two are not court procedure.
But review is a court procedure.
Yes, yes. Anything else? Yes.
To comment, earlier the dissenting judgment mentioned that Dr. Najib paid the price for the mistakes made by the lawyer.
Thank you. I forgot about that. In fact, the word he used, you managed to decipher from that, because I thought that was a very strong point he made. The learned judge said that he paid a heavy price for the mistake of lawyers, which ought not to happen. Because if you exercise justice and process properly, a mistake of the lawyer is a mistake of the lawyer. If you want to punish a lawyer, there is contempt, there is disciplinary proceeding. The court never took contempt against the lawyers. So why should Datuk Sri Najib suffer? Especially when you have already determined, the prosecution also determined that the application for adjournment was genuine. It is not a ploy to delay, right? Okay. That's a good point. Right? So it's a very serious point. They made a finding that there is admission that the lawyers were at fault. The lawyers themselves admit. So the lawyer's fault should not be attributable to the client.
So, earlier on, prosecution's president mentioned it hopes that the SRC case, the effect says will end, no more litigation. How would you respond?
No, I think SRC case very unlikely will end that fast. Very unlikely. Yeah, because I think my client is, even if my client gets let's assume for a moment he gets a pardon, I think he will still want to fight in court because he's very determined that he did nothing wrong. Okay, he was misled by people in the SRC. He never moved the money. He never had the control of the money because he was a prime minister. Why should he have anything to do with the account of SRC? So, well, we think this case it has been decided on grounds which are a bit difficult to comprehend. And that is the reason why we thought we should take it all the way. And we are surprised that the current federal court, the federal court just finished, didn't even allow. Why not allow him to re-argue the matter? Because he was not prepared the last time. What is the problem if you allow him to re-argue the matter? Is there a fear that he may get acquitted? Yes? No. As a result of the minority judgment, which I thought was a lot stronger than the majority judgment, there is avenue that is open. Because there are cases that say review is not only once. If there are grounds, as long as there are grounds for a fresh review, you can always review. And the other thing is, of course, we got the United Nations as well as the pardon matter that is ongoing. He just asked me. I said, I cannot tell you at this moment. Okay? Yes. No, there is no time period. There is no time period. But the first review we file in within 2 weeks. The one that you just heard. Within 2 weeks, we file it after the first federal court decided. So we will try to do it expeditiously. Any other question? Thank you. Thank you.
Iyalah. Tadi nak kena menang banyak sikit.
Hello， 荧幕前观众朋友，大家中午好！现在呢已经是12:38了。那现在我就跟大家来做一个快速的总结，基本上呢是关于今天在布城司法宫呢是有2大的案件，就是前首相纳吉以及这个沈可婷的。那么我们先来说一下这个纳吉的部分哦。如果你有看我们较早前的一个直播的话呢，就已经知道纳吉呢是败诉的。 联邦法院呢是以4-1的多数票裁定驳回前首相纳吉为寻求检讨 SRC 国际公司4200万令吉血钱终极判决所提出的这个申请，所以这意味着纳吉呢必须得要回到监狱继续去服刑的。那么刚刚的时候呢，就是这个主控官西旦巴兰呢，他也是有跟记者说了一些话。他就有提到没有人呢是可以凌驾于法律之上的。然后他也有提及关于这个在这个第137条文下呢，是允许在证明存在违反自然争议或滥用程序情况下呢提出司法审核。那么虽然纳吉这一次是败诉，不过技术上呢，他还是可以再次援引这个条文去申请检讨裁决。不过他有提到，如果呢，其实这个提成的过程，然后也是必须得要符合这个法律的规定哦。那么这个是他说的部分。然后接下来呢，刚才大家看到的第二位讲话的人呢，就是纳吉的代表律师，就是沙菲义的。然后沙菲义呢，他就有表示，他虽然呢对今天的这一个判决呢是感到他们的团队是感到极度的失望。不过呢，因为刚刚有提到嘛，它是4-1，那么因为也有其中一票呢是其中一票，也就是我们的这个联邦法院的这个法官阿杜拉曼，他是持异议的，所以他讲说这一点呢，还有他在庭内所说的话，也有给他带来一些鼓励的。那么他刚刚就有说到特别点到这一名法官呢，他就说正义呢不单是为了找出某人有罪或者是无罪，因为他其实有更宏大的这个概念，就是在裁定一个人有罪或无罪的时候，他们接受的这一个审讯的过程呢，必须得要是公平还有公正的。然后他也有提到的，就是呢，接下来他们会做的这个举动，就是他们会把这个少数的判词还有多数的判词，他们就是会整理好之后呢，他们就会交给这个联合国。如果你有关注这个纳吉案件呢，就是在今年1月的时候，纳吉有向这个联合国的任意拘留问题工作小组呢提交这个申诉，那么就要求这个大马的政府释放他，或者是重审这个 SRC 案。所以呢，他们现在会做的事情就是会整理详细今天的这个判词之后，就是提交给这个联合国。然后关于他们还会不会再次的，就是援引这个137条文呢，就是提出申请刚刚呢，这个沙菲义他是语带保留，他就是没有说会或不会这个是接下来我们可以看一下，接下来他们还会否有其他的这个动作。不过暂时他是没有透露更多的。OK， 好的，我们看完这个纳吉的案件之后呢，接着跟大家跟进一下，就是6年前轰动全国的文心绞车8死案被判罪名成立的这个沈可婷呢，今天他是来到这里呢，是要继续他的审讯，就是上诉的部分。今天早上9点开审之后呢，他的首席辩护律师郑保德呢就指出，就是他的当事人沈可婷在审讯的过程当中呢，是受到偏颇司法不公的。然后他也在他的这个陈词指出，这是因为控状中指上诉人呢鲁莽驾驶或危险驾驶，那么这出现了相关重叠的这个性质。那么在经过2个小时的审讯之后这个副主簿官呢，他就有宣布沈可婷上诉呢是暂缓，他的审讯会就是暂缓审讯，就择定会在4月11号再继续来进行审讯的。那么我们也有看到呢，其实因为向来沈可婷是相当的低调然后今天他就有难得就露出他的笑容，然后也有命媒体的这个要求呢，就跟他的这个首席辩护律师郑保德呢来合照的。 好，这里就是沈可婷的上诉案件，然后就到这里呢是告一段落，然后过后我们接着呢就跟大家补充一项资讯，是关于这个前首相纳吉的这个案件的，然后。大马律师前工会主席杨应波呢，他就提到关于这个纳吉，如果呢他是提这个第2次的检讨申请，他是说是还是可以的，就像我刚刚提到的，主控官说技术上面还是可以再提。不过呢，这个杨应波他就认为呢，这么做也是徒劳无功的，因为除了一位联邦法院的法官就是持异议之外呢，其他的这个联邦法院的法官呢，都已经是审理过这个案件，因此如果要进行第2次的检讨申请，那就得使用上诉庭法官。然后还有提到说，就是在他的印象当中是没有人是成功过的。所以如果呢我们之前就有看到说，如果他就他的这个最后一搏呢是失败告终嘛，所以他的命运会不会就是这样子呢？其实还有的另外一个途径就是向最高元首申请特赦。不过这一点呢是刚刚我们是完全这里是没有提到的啦。然后过后关于他会不会做所谓的第2次的检讨申请呢？沙菲仪呢他是语带保留，没有透露更多。OK， 所以这个是今天在布城司法宫2大案件的基本重点。如果大家还要看更多的内容的话呢，就可以留守我们应该是傍晚会出的这个百格日报。那么今天真的很感谢大家留守在百格的直播。那么我们今天的这个直播就到这里告一段落。不过等会儿呢，我们2点。也一样会有这个百格午报的。如果想要关注国内外的重点新闻的话呢，就记得要留守在百格的直播间。好，我们就下次再见，拜拜。